to the final day of summer school, everybody. You made it. So this morning is our moot court exercise that you've been preparing really hard for all week. So I'm just going to explain the procedure and then we will open up with the first team. So, as you can see in front of you, we have 4 teams at the top of the auditorium. The first team represents John, the complainant in this case. The second team represents the government of Narnia. The third team represents the Rainbow Coalition, who present an amicus brief. And the fourth team represents the Respect Our Families team, and they will also present an amicus brief. So the order of proceedings is as follows. John's team will go first. They have 10 minutes to make their opening arguments. At any time, they can be interrupted by the government team. The amicus teams are not allowed to make objections. It's just the government team and the complainant team who can object to each other's arguments. So after that 10 minutes, we will hear the arguments from the government team for another further 10 minutes. Then we will hear the arguments from the Rainbow Coalition also for 10 minutes. And finally, we will hear the arguments from the Respect Our Families team for a further 10 minutes. I will be keeping time. I will be sitting behind our 3 CRPD committee judges here at the front. So for some of our advocates who won't be able to see me hold up signs, I will ring a bell when we're out of time. Okay, so that will mean we should stop. You must know that also the judges can interrupt you at any time to ask you questions or to clarify. And once we have heard from all 4 teams, we will return to the first 2 teams for rebuttal. First to John's team and then to the government of Narnia's team. And once the rebuttals have been made, then we will, and again, objections, interruptions from either team can happen during this period, and questions from the judges. And at the very end, each team will have 1 minute to sum up their arguments. We will return to all 4 teams to sum up their arguments, again starting with John, then followed by the government of Narnia, then followed by the Rainbow Coalition, and then followed by Respect Our Families. Okay, is everything clear? Are we ready to start? Okay, so I will hand over the floor to our CRPD committee, who can then, when you are ready, invite the first team to start.
Welcome, and I invite the first team to begin to present their case.
Good morning, the committee and the audience. May you please account me. My name is Hannah Kim, and I'm the leading advocate of John's team, and I and my team represent John, the complainant. This case is about multiple violations of the United Nations Convention on the Rights of Persons with Disabilities by the government of the Kingdom of Narnia. In our case, John has been discriminated against on the basis of his disability by the government of the Kingdom of Narnia in rebuttal of his intended marriage to his partner, Ali. Complainant John respectfully requests that the decision of the court in the Kingdom of Narnia refuting his intended marriage be reversed for the 4 reasons. First, the government has breached the right of a person with disabilities to enjoy legal capacity on an equal basis with others and discriminated against a person with disabilities, which is prohibited by CRPD. Second, the government has not provided the appropriate support required by the complainant to exercise its legal capacity. Third, persons with disabilities have a right to marry and a right to privacy and family, but the government breached these rights of the complainant. Finally, the government violated the Article 4 of CRPD. Okay, let me be more specific. First, the government has breached the right of persons with disabilities to enjoy legal capacity on an equal basis with others and discriminated against a person with disabilities, which is prohibited by the CRPD. According to the Article 12.2 of the CRPD, states parties shall recognize that persons with disabilities enjoy legal capacity on an equal basis with others in all aspects of life. In addition, General Comment Number 113 states that unsoundness of mind and other discriminatory labels are not legitimate reasons for the denial of legal capacity. Moreover, General Comment Number 114 states that legal capacity is an inherent right accorded to all people, including persons with disabilities. In our case, the complainant was discriminatorily denied of his legal capacity to get married on the basis of the government's alleged lacking of his decision-making capacity. As General Comment Number 114 points it out, the concept of mental disability is highly controversial in and of itself. Mental capacity is not, as is commonly presented, an objective, scientific, and naturally occurring phenomenon. Mental capacity is contingent on social and political contexts, as are the disciplines, professions, and practices which play a dominant role in assessing mental capacity. Obviously, it is not required for everybody to pass a mental capacity test to be entitled to get married. In our case, the government has made a decision not to permit the complainant to marry based on his disability, even though he satisfied the notification requirement under the Marriage Equality Act 2010. And discrimination on the basis of disability is prohibited by Article 5 of the Convention. Second, the government has not provided the appropriate support required by the complainant to exercise his legal capacity. Article 12.3 of CRPD requires state parties to take appropriate measures to provide access by persons with disabilities to the support they may require in exercising their legal capacity. In addition, General Comment Number 117 clearly states that support in exercise of legal capacity must respect the rights, will, and preferences of persons with disabilities and should never amount to substitute decision-making. Moreover, General Comment Number 129F provides that support in decision-making must not be used as justification for limiting other fundamental rights of persons with disabilities, especially the right to marry. Furthermore, General Comment Number 122 clearly provides that safeguards for the exercise of legal capacity must include protection against undue influence. However, the protection must respect the rights, will, and preferences of the person, including the right to take risks and make mistakes. In this case, the complainant has a state-appointed support person for financial decisions. When the complainant told his support person about his plans for the upcoming wedding, the support person did not provide appropriate support to the complainant as a financial counselor. If he was worried about the financial consequences of the wedding, he could have provided the complainant with clear and extended information about such consequences. The support person also could have helped the complainant find a good way to manage his financial matters. However, the support person did not take any of these necessary and appropriate steps to support the complainant. Instead, he exceeded his power as a financial counselor, made a very personal and intimate decision, and wrote a letter of objection to the marriage registrar to oppose the proposed marriage. Additionally, the government made a decision exclusively based on the support person's incompetent opinion and did not adequately consider the complainant's own will and preferences and his family's full support of his decision and active involvement in the wedding preparations. Given the conflict of interest and the violation of the complainant's privacy into securing such evidence, the government should have asked for another opinion. For example, one of the family members designated by the complainant could have given his or her opinion to the government as an informal support person, because a family member can be the person who knows the complainant very well. Third, persons with disabilities have a right to marry on an equal basis with others, but the government breaches this right of the complainant. According to Article 23.1a of the CRPD, state parties shall take effective and appropriate measures to eliminate discrimination against persons with disabilities in all matters relating to marriage, family, parenthood, and relationships on an equal basis with others, so as to ensure that the right of all persons with disabilities who are of marriageable age to marry and to found a family on the basis of free and full consent of the intending spouses is recognized. In addition, as I mentioned earlier, Article 12 of the Convention does not allow any discrimination on the basis of mental capacity. In our case, the complainant has reached the age to get married and has known his fiancée for the past 2 years. For months, he has been expressing his free and full consent to this marriage. As to the matter of unsound mind under the Civil Marriage Act 1957, the government has never been able to prove that the complainant has had an abusive relationship. Marrying someone older and with immigration status cannot be a good evidence to prove that there has been an abusive relationship. There is no evidence or even a small sign of fear, aggression, threat, deception, or manipulation, which is required by General Comment Number 122 for proving undue influence. Of course, it would be possible that the complainant's fiancé is disguising their true nature in order to secure a visa, but this is the kind of risk to be taken by anybody with respect to getting married, as we could all be manipulated into getting married because of our financial or social status. Living is about trying something new, making mistakes, and learning from these mistakes. No one should be denied the right to marriage based on their will and preferences only because of a risk that the other party might not be honest. Fourth, persons with disabilities have a right to privacy and family, which is protected by Article 22 of the CRPD. Article 22.1 of the CRPD provides that no person with disabilities shall be subjected to arbitrary or unlawful interference with his or her privacy and family. In this case, the complainant was denied of his right to marry because of the decision of the court in the Kingdom of Naria based on the above-mentioned discriminatory and illegitimate reasons, and therefore the government has arbitrarily interfered with the complainant's rights to privacy and family. Decisions related to marriage to a partner and being a family and the relevant process of decision-making are the issues of privacy and how they affect the lives of the persons who are the subjects of that decisions. Finally, the government violated Article 4 of CRPD, especially B, D, and E of Article 4.1. According to Article 4.1 of CRPD, state parties shall be take all appropriate measures to modify or abolish existing laws, regulations, customs, and practices that constitute discrimination against persons with disabilities. D. Refrain from engaging in any act or practice that is inconsistent with the present convention and ensure that the public authorities and institutions act in conformity with the present convention. And E. Take all appropriate measures to eliminate discrimination on the basis of disability by any person, organization, or private enterprise. In our case, under the Civil Marriage Act 1957, Section 2D, marriage will not be permitted if one of the parties is of unsound mind. But the term unsound mind is not further defined under the 1957 Act. Additionally, 1957 Act Section 6 requires an objection on the ground of unsound mind accompanied by a certificate of a registered medical practitioner supporting the objection, even though medical practitioner cannot be the only person to prove the mental capacity. This provision of the law is only based on the medical model of disability approach, not the social model of disability approach. Although these laws constitute discrimination against persons with disabilities, as I mentioned earlier, it is still enforced in the Kingdom of Naria and was neither abolished nor modified to be compatible with CRPD. Moreover, the government, including the court in the Kingdom of Naria, did not act in conformity with the present convention, and the above-mentioned discrimination took place. For example, the court explicitly relied on the opinion of the support person and therefore failed to perform its obligation to act consistently with the CRPD. Based on all of the above-mentioned reasons, the decision of the court in the Kingdom of Naria refuting the complainant's intended marriage should be reversed, and the relevant discriminatory laws should be abolished or modified so that John can exercise his right to marry and the Kingdom of Naria will be comply with CRPD. Nothing about us without us. Thank you.
Thank you. I just have a question. Could you resume all the articles which you are alleging have been violated?
Which article? Could you repeat?
Yes. Could you summarize the list of violations that you're alleging?
The article?
The articles, yes.
Okay, CRPD article, do you want me to talk to you about the specific article number?
No,
Yes,
just name the article.
article number and subsection if it's relevant.
Okay.
Yeah.
Okay, we consider that the articles of the Convention violated by the states are Article 12, Section Article 12, Section 2 and 3, Article 23, Article 22, Section 1, Article 4, Section 1, and Article 5.
Article 4, Section 1, B, D, E.
More specific.
And Article 5 on the basis of
Violation of the right to
discrimination on the basis of.
Yeah, but it's like we tackle it like transversally. It's like it's on the basis of discrimination, on the basis of disability. Yeah.
And I have a couple of quick questions. Has Narnia ratified the CRPD and the optional protocol?
Yes.
And what steps did you take to exhaust domestic remedies?
We didn't understand the question, I'm sorry.
What steps did you take to exhaust domestic remedies at the national level before applying to the committee?
The complainant went to court to get married, to get a good decision to get married, but the court didn't make a right decision, so he just decided to go with this committee.
Thank you. And we've exhausted all intern remedies possible before coming here.
Thank you. And another question is, could you speak a little bit more about why Mark was appointed as a financial support person, and how was that on the basis of legislation, a government decision, a court decision, or John's personal choice or a private contract?
The state appointed the support person for John, but there is no proof that why the support person was appointed for John, because John is now independent living, and he has very supportive family. But anyway, Mark was appointed as a supportive person to give John the financial counseling, but he didn't do his job.
Sorry, just to clarify that just a little bit more. So that was not John's decision to appoint Mark, is that correct?
It's not John's decision because we cannot find anything that John appointed Mark as his support person. I think the state appointed Mark the support person for John. It's not John's decision at all.
Thank you. And my final question is in relation to the Marriage Equality Act. So that took place in 2010 and came into force. Is there any element of, do you believe that there's any element of intersectional discrimination in this case?
So according, yes, it seems that in the Equality Marriage Act, it's required from same-sex couples to notify their intention to get married, while this is not required for other couples. So that could be a massive violation on the basis, discrimination on the basis of sexual orientation, if that was your question. Thanks.
Yeah, thank you.
A clarification question. You raised Article 22 on respect for privacy, and I would like to understand the links you're making in terms of right to privacy and right to marriage.
We think John's privacy was violated because getting to marriage is kind of a very personal decision. But John really wanted to get married with Ollie, and his family is very supportive of his decision. But Mark didn't ask anything to John. He didn't consider John's intention. He just notified the registrar of John does have unsound mind, and he cannot make a decision by himself. So John's interruption itself is, I think, we think is violation of the privacy of John, the complainant.
Thank you. There's also the fact that the government only relied on the opinion of the financial state-appointed support. So the state relied on the opinion of someone exceeding his powers. And so by exceeding his powers, the state-appointed support violated John's privacy. So seeing that, the government should have required further investigation by relying on a letter that clearly violated John's privacy. The government became an ally to this intrusion in privacy. Thanks.
If there are no more questions, I think we can go to hear the arguments of the state.
Good morning, everyone. My colleague and I together will be opening on behalf of the government of Narnia. We believe there was no instance of disability discrimination in this case, and that the necessary precautions were taken in order to ensure John's safety. As we see in Article 5.1 of the CRPD, all persons are equal before and under the law and are entitled, without any discrimination, to the equal protection and equal benefit of the law. At no point in time did Mark unfairly treat John due to the fact that he has an intellectual disability. The letter of objection was submitted to the registrar with no intentions of malice. Rather, was submitted for John's protection against exploitation and possible abuse. Additionally, there was no inequality displayed when John and Allie submitted their request for marriage. This protocol of notifying the state of intentions to marry at least 2 months in advance is followed by every citizen, not just those in a same-sex marriage. As shown in Article 12.4, appropriate and effective safeguards are provided in order to prevent abuse. As John's state-appointed support person, it is Mark's responsibility and duty to protect and aid John financially. However, with marriage comes potential financial obstacles or injury. John not informing Mark on his decision to get married shows us that he may not have the full understanding of how serious this decision is, because with marriage has to do a lot about finances. He may not grasp that his finances can actually be financially affected in a negative way. Mark is simply doing his job and making sure John understands the pros and cons of his decision.
Our responsibility as a government of Narnia, and in reference to Article 16 of the CRPD, is to prevent exploitation, violence, and abuse of John from his partner, Allie. In order to prevent the occurrence of all forms of exploitation, violence, and abuse, it is our responsibility to uphold Mark's objection. Mark has all the legal standing to make the argument on behalf of John, as he has been doing so as John's fiduciary. We are not preventing this marriage. However, as a government of Narnia, and in accordance of the CRPD, it is our responsibility to take the necessary safeguards in order to prevent the exploitation of John. In alliance with Article 23.1, the government of Narnia has put forth the effort in order to eliminate discrimination against persons with disabilities in regards to relationships and the solemnization of marriage. John has the legal capacity to fulfill his wishes and desires in reference to marriage. However, our responsibility of the government is to ensure that both Allie and John equally understand the consequences of marriage, specifically in this case, the financial aspect. According to the Civil Marriage Act, a registrar who receives an objection with these reasons listed above shall refer the matter to the Chief Registrar, in which the appropriate measures were then made to notify Ali and John of the objection. These rules and procedures have been upheld throughout the judicial process by the government of Narnia. Furthermore, the process in which we have reached our decision was implemented in accordance with the CRPD and with the best intentions of the citizens of Narnia in mind. In conclusion, we believe that we have provided due process in our decision and have upheld the values and ethics behind the CRPD. Thank you.
So maybe I just have a short question. You said that the practice of notifying the state 2 months in advance is followed by other couples. Is that enshrined in legislation or is it practice?
By practice. So yeah, all citizens need to report their marriage, intentions of marriage 2 months prior to marriage.
And my other question is, the appointment of John as a supporter, does that reflect on, the appointment of Mark as a supporter, does that reflect on John's legal capacity? Or does he have full legal capacity under the law? So just has John's legal capacity been restricted or denied in any way?
He has full legal capacity, but when making decisions financially, Mark is there for his extra support, but not substituted decision, just support.
There's also, it doesn't say that John and Mark prior to this have, it's never been against John's will, and their relationship has never been questioned before this.
I have a follow-up on that question actually. I'm just trying to understand the role of the supporter in your legal system. So you're saying that in the opening remarks you said that the role of Mark, of the supporter, was to protect John. So I wondered, so what's the role of the supporter in this relationship? Because you're mentioning this to protect, but then also you say to understand the legal consequences of their acts. So I want first a clarification on that. What's the specific role of the supporter, taking into account that you are trying to implement Article 12 of the Convention?
Mark is supporting John on financial decisions. He is not involved in her. He's private life. He's making the statement on the civil register and the court because he's worried about how he's financial and the consequences related to marriage, not the private of the relationship between Ali and Mark. He's worried about his financial issues related to the relationship. So it's different the perspective that Mark has in this situation. In this situation.
Additionally, Mark is not trying to prevent this marriage from happening. He's just taking the necessary precautions because although he is his financial supporter, we do not believe he's exceeding his power because marriage does have to do with finances.
So to understand then, what happens if Mark and John don't agree in a decision? What's the consequence in terms of the relationship of support? Can John be prevented to make the decision if Mark doesn't agree with a decision related to financial decisions?
So based on the facts that we have in front of us, Mark and John, if they don't agree
this is like first time when they have it? Thank you. Thank you. Just also a clarification. You raised Article 16 of the CRPD that in order to uphold Article 16 and prevent violence, abuse, and exploitation, that this decision was made. On what basis did you determine that John was at risk of violence, abuse, and exploitation by going ahead with this marriage?
So according to the sheet of the Civil Marriage Act of 1957, it says that the process in which, so after Mark's objection, that was then reported to the registrar, it's the registrar's responsibility to then report if he has significant proof to the chief registrar. And in this case, it went all the way there because the immigration status of one or each of the parties to the intended marriage who is a foreign national, so in this case, Ali, John's partner, would fall under that category. So that would just say that we're just taking the necessary procedures and precautions.
So it was on the basis of the migrant status? Yes. And were there any other verifications of any risk in that relationship besides on the basis of Ali's migrant status?
Listed in the fact sheet we were given, it only, we only know that Ali was a migrant, and that's all the information we got after that sheet.
So in any case where a citizen of Narnia would be intending to marry a foreign national, a migrant in Narnia, would this always be invoked? The marriage would be questioned.
It's related to the Marriage Act, and the Marriage Act is for every citizen in Narnia. So if another citizen wants to marry with an immigrant, and the immigrant doesn't understand English, for example, and doesn't understand the consequences of the legal procedures in Narnia, it's going to be affecting the other partner. And it's also related to the risk that can represent for the nationals. And we, as a state, has to be in precaution and prevention of our nationals.
Sorry for taking the floor again. I just wanted to ask the government if there is any plans to amend the Civil Marriage Act in respect to Section 1A, Section 2B, referring to unsound mind, or the government believes that this is compliant with the Convention on the Rights of Persons with Disabilities.
The government is in the process of changing that. The term unsound mind is, there's no specific legal definition. It's not a specific term, but for disability, because it could unsound mind is a very broad term. It could mean someone is drunk, someone is on drugs. It's not just specifically directed towards those with a disability.
And if the state wants to make changes on the law, it has to go through Congress. And it takes a lot of time to it. And it takes to make advocacy in every party inside the Congress. So it will take time, but if we wanted, we have the political will to make changes in the future related to it.
Thank you very much. I would like to ask the first amicus to intervene, the Rainbow Coalition.
Good morning, dear Chair, committee, respected members. I represent the Rainbow Coalition, which is a human rights organization. I'm happy to introduce my colleagues, my advocate assistant, Yanka Espinoza, and our support team, Sally, Sabina, and Tatiana. We are, as an organization of human rights for all people, we mainly concern about people's rights to marriage, to sexual orientation, to all legal capacity issues. In this case, we are smelling a discrimination and I would say a discrimination against people from on the basis of nationality, on the basis of age, and also on the basis of disability. We hope now you can look to our argument as a step towards enforcing human rights practices in our great kingdom of Narnia, since we believe that the progress happened after the approval of the CRPD in our kingdom is a jump forward, but we still know there is a lot to be done regarding the approval and the practice of the rights mentioned in this convention. We believe recognizing the rights of people is not enough to enjoy these rights completely. We know our state, our government should have to take practical measures on the ground in order to ensure and secure practice for these rights, specifically for people who are in need of support. In this case, we believe that our government should be taking measures or steps towards complying with Article number 4 of the CRPD, which is modifying our legislations and our administrative procedures in order to guarantee legal protection for John's rights to get married of his own choice with his own capacity, and also to support his financial rights and other rights. We believe Article 12, which is in the convention, is superior to our national law according to our legislation set of legislation in Narnia. So we believe the government should take the practical procedures in order to change our laws. Okay, Regarding this, John's right to get married of his own choice, we believe Mark has exceeded the lines and the mandate of his work as a person appointed to give financial advice to John, nothing else. Absolutely. We cannot understand and we cannot accept that John is deprived of his right to marriage under the alleges of protecting his financial rights. So we believe our your Excellency should urge the government of Narnia to immediately ask or take procedures in order to approve the marriage and to stop ceasing it in order to let John enjoy his right to marriage. In the same time, if they have if Mark and the government have any alleges and any worries or suspicions about his financial rights, they shouldn't stop or end or cease his right to marriage. They should start immediate measures in order to protect his financial rights. And Mark, instead of asking to stop this marriage, he should run immediately towards developing procedures and steps in order to protect John's rights. In the end, I just would like to point out that the procedures and the legislations and regulations should give John the right to change his financial advisor in order to help him practice his legal capacity to the extent that guarantees that the compliance with the principles of the CRPD is always there in our brains. And I believe this committee will understand our argument and will help us to practically empower John to practice his legal capacity and his rights completely. Now I refer the mic to my colleague, Bianca. She will give a conclusion.
Thank you. Dear members of the committee, the audience, I would like to talk more about marriage as one of the universal social institutions. Marriage represents the commitment and the faith law two people share. Marriage is more than a physical union. It's also a spiritual and emotional one. It's the security of knowing that no matter how bad you feel or how many people turn their back on you, there's someone who is still going to love you and be on your team. I would like to ask a question. Does a man have the right to marry? Does a man with disability have the right to marry? This is the key question that we should confront. The right to marry consists of many levels of decision making. John, of course, has gone through this process within 2 years of dating Ali. He had to decide above all if Ali is the right one, if they share some ideas, dreams, and lifestyle. Now, Mr. John and Mr. Ali are subjected to harmful stereotypes. John is subjected to multiple discrimination on his intersectional identity as a person with a disability and as a gay person. The Civil Marriage Act of Narnia contravened the government obligation in accordance with the CRPD, especially Article 5 on equality and non-discrimination, Article 12 on equal recognition before the law, and Article 23 on respect for home and the family. The multiple discrimination based on disability, sexual orientation, age and citizenship has negatively affected Mr. John as a dependent partner.
Mr. John is treated as someone incompetent to marry and Mr. Ali as insincere with unfair intentions. In accordance with the Article 12.2 of the CRPD, the government of Namibia shall recognize that everyone enjoys full legal capacity on an equal basis with others in all aspects of life, and that all forms of support in the exercise of legal capacity are based on the will and preference of the person, not on what is perceived as being in his or her objective best interests. Mark's letter of objection cannot be therefore taken into account and be used as justification for limiting Mr. John's rights to marry. This practice of the government of Namibia, as well as the Section 2D of the Marriage Act, that in effect violates the CRPD, must be abolished in order to ensure that full legal capacity and enjoyment of all human rights is restored to all the Namibian people with disabilities. Thank you.
Just a short question. You have mentioned that he was discriminated against on the basis of age, nationality, disability, and then you mentioned on the basis of his sexual orientation as well. But you're making your arguments on the basis that the state has recognized him as incompetent and is interfering with his legal capacity. What is the intersectional nature of the discrimination that you're arguing? Why did you raise age, nationality, and sexual orientation?
It was mentioned in the complaint letter to the court, whereas Mark is concerned about Ali's intention to take a visa, or because he's a migrant, or his age is older, and a man at the same time. And this is indicator that he is exceeding his nomination to work as a financial advisor. He does not have the license or even the capacity to decide which basis John should handle his personal life. He's in charge of only financial advice of John. So he couldn't go that far in his interventions. Even the family, Ali's family, John's family is supporting him and being involved in the wedding arrangements, preparations. So the family is in support of John, but the person, Mark, is not. Which means that here the government of Namibia should stop a little bit and watch what are what is the necessary code to be. Is to stop the marriage in order to develop or to see what Mark's limits are or not. Okay.
And similar objections that Mark has raised are rarely upheld by the Registrar of Marriage with respect to heterosexual couples.
And maybe also refer the distinguished members of the committee to the ICCPR, International Covenant on Civil and Political Rights, to which Narnia is a member also, and it protects the rights of, again, to be discriminated against. And in Article 4 of that convention, we know that no one's right to be presented, to be recognized a person before the court can be derogated from anyone. It's a non-derogable right. Besides, Article 26 of the ICCPR has been violated. The right that prohibits discrimination on any basis, including age, sexual orientation, or anything else. Also, the right on Article 17 of the CCPR, the right to privacy, has been violated by Narnia. Besides, talking about the sexual orientation, let us refer the committee committee members to the Yogyakarta Principles of 2006. And they are indeed of the recommended nature, but they combine everything, all human rights principles and standards referring to sexual orientation and gender identity. And in Principle 24.g, it says that everyone, regardless of one's sexual orientation and gender identity, has the right to marry anyone a person chooses.
Thank you. So just a clarification, so Mark is the person who's discriminating here. So it's a matter of ensuring that discrimination between private actors is not happening, or is there any other issue with the law or the practice of the Narnia state, which is that issue about concerning discrimination on those bases?
Thank you, Mindy. Actually, our contention is the state is engaging in discrimination by basing its decision solely on the objection of Mark, which is motivated by the nationality and age of Ali. So that's one of the bases of the state decision, well, the main basis is Mark's decision.
So it's about discrimination against Ali?
No, well, it's discrimination against John. John ultimately is the one who wants to marry, and the state is not allowing John to marry based on the objection of Mark, which is motivated by discriminatory concerns. The state is basically acceding to those discriminatory concerns.
And the question of discrimination on the basis of sexual orientation, so that's just because Mark is discriminating against John on that basis?
No, it's the registrar of marriages who is usually upholding those objections with regard to homosexual couples, but not with regard to heterosexual couples. So it's not in the law itself, but it's a state practice, it's a court registered practice, which amounts to indirect discrimination. So the numbers show that there's a deep, a deeply rooted discriminatory approach to persons who was different to not heterosexual couples.
But it comes all from the Marriage Act that is against and violates the CRPD, namely Section 2.2.
I'm sorry.
That should be abolished.
I'm just trying to understand the arguments. So you're arguing that John has been discriminated on the basis of, you say, intersectional discrimination, and you mentioned sexual orientation, but what I see is that there has been an effort from the state actually to recognize.
In the legislation, yes. In the legislation, yes, there is state efforts to enforce the CRPD and its principles, but in practice, no. Because, and one evidence is that what has Mark said, that he is suspecting exploitation on the basis of whatever Ali is trying to abuse John in order to take a visa or citizenship, whatever, or passport. But in reality, he is doing something else, not his job. And the government immediately approved his letter and stopped the marriage. The government should have done two things. First of all is to ask Mark to only be committed to his work as a financial advisor. And the other thing is to order him to take measures in order to protect Ali's financial rights. And the other thing is to look up to the regulations and procedures which they are have to be changed in order to guarantee same sex couples to get married, to practice that, not only to have it as legislation on paper.
That was actually my question. I mean, the state has passed same-sex marriage, and still what we're claiming here is that this is discrimination on the basis of sexual orientation. So that's you already responded to this, but I just wanted to make the point. And the second point I wanted to make is, so you're claiming also that there has been discrimination on the basis of nationality and age, which I understand is basically because Ali's nationality and Ali's age, no Mark's nationality and age. So I would like to understand why you're claiming that the discrimination to Mark's applies to this case, and how you're claiming discrimination on those bases, because Ali is not the complainant.
It's the principle of associational discrimination, which is that John is experiencing discrimination because of his association with someone from a different nationality and someone who's older.
Thank you. Can we pass to the second amicus, please?
Good morning. I'm Sarita, and I would like to introduce my other fellow advocate, Sushma, Kapiva, and Nuri. Yeah. And then we are the faith-based organization. Respect our family, because we do believe in our culture, and then we respect our culture, belief, and our tradition. We have very strong family values. We respect the sanctity of marriage as a bond between man and woman for the sole purpose of reproduction. In this case, John and Ollie, they don't have a good bond. So this is not good for the reproduction. Because due to their relationship, maybe in the certain time, they will have a divorce. Divorce can disrupt the society, and then it will create effect on their individual life and as a whole in the community. We want to preserve the beliefs of the community, because which will support us to respect our value and support us to respect with the dignity. We believed the marriage is based on we believe the marriage is the union based on the equality, honesty, equality, and the affection with each other, which we cannot get from the, which John cannot get from the Ali.
Thank you. So going on to our very strong family-based organization, Respect Our Families, and we actually have love at the upper end of our organization, and we only want to bring good to mankind. So taking on from what our objectives, as Sarita said, I think our main argument is going to be on certain points, and I think the first one is that John is the younger person in the relationship, and in addition he has an intellectual disability for which he's been appointed a support person to assist him with financial decisions. Now John and Ali had hidden the fact of their getting married, from Mark, which to us as the Kingdom of Narnia, where there's absolutely no dishonesty allowed because it's based on really strong values and principles, it suggested a lot of dishonesty on the part of John, which is a little suspicious because everything is always honest in the land of Narnia. And we just feel that, there's something influencing John to make a decision. There's something suspicious about this hiding a bit of it from Mark. So we believe that allowing this marriage to go ahead is absolutely wrong because there are absolutely no safeguards, and there's going to be a lot of exploitation of John by Ali. And We feel that the only sole purpose of Ali, because one is we know that he's a migrant and his whole sole purpose to enter this marriage is to get a visa. And we really have no information apart from the fact that he's a migrant and needs a visa. We have no information about his health status, his marital status, family, his culture. We have absolutely no idea. We only know that John and Ali are in love for 2 years, and John has decided to marry him. So we just feel that we also have another angle to John's family being really supportive to this marriage, because they've been looking after John for some time, and there is an angle of them wanting to have John being taken care of, now by someone outside. And there is a tiny financial angle to it. We just kind of feel that there's something slightly suspicious, because we're not against the family being supportive, but they're together with them, but we kind of feel as the Kingdom of Narnia, we want to protect the family as a whole. And we just feel that John is just going to lose his place in this community by taking the decision. So we're going to make it go all the way to kind of, see that he makes the right decision. We don't want to stop him, but we want to see that he makes the right decision. So I'm going to hand over to Tabuha, who is now going to talk towards a legal argument.
Thank you. I would like to address some of the issues that have been raised with respect to the application of the CRPD. The complainants have argued that the process that John has had to go through violates Article 5 of the CRPD. The amicus is of the opinion that there is no actual violation, there is no discrimination, because in terms of Article 5.3, the state is required to put in place measures to ensure that there is reasonable accommodation. The very fact that there is a support person that has been provided for John is one such example of reasonable accommodation that has been provided by the state. And it is worrisome that John actually circumvented the support person that he was provided by the state. Yes, he does have the legal capacity to make decisions, but however, the existence of the support person is to ensure that he has all the information, he has all the relevant information that is necessary for him to make the right decision. We also believe that in terms of Article 12.2, which protects John's right to protection of his legal capacity, there is need for him to be able to give free and full consent. This is also in line with the provisions of the Civil Marriage Act. For him to be able to give free and full consent, he has to be fully informed. So Mark has that position to give information to John, and when John does not have adequate information, it's not clear. It will not be clear that when he makes the decisions that he's making, he knows exactly what he's doing. In terms of Article 12.4 of the CRPD, the state parties are required to ensure that there are appropriate and effective safeguards in exercising legal capacity to prevent abuse. And we feel that Ali is in a position, Ali in a sense is also a support person, although he's an emotional support person. And the fact that there hasn't been any, I would say, objective means of verifying that the decisions that they are making are made with full knowledge, it means that the safeguard against Ali unduly influencing John has not been dealt with. We also feel that in terms of Article 22, it has been argued that there is a breach of the right to privacy. Yes, on the face of it, obviously interfering or limitation on the right to marry would be a violation of the right to privacy. But however, this right, like all rights, is not absolute and can be derogated in the interests to safeguard against exploitation. And it is important to note that the state has not stopped this marriage. What the state is basically saying is that there should be an investigation and that all relevant information comes to mind so that it is clear that the decisions that John is making are correct.
Well, I really want to state that members of the committee are in the breach of their own procedures. And I think this case shouldn't be considered here at all because as applicants stated, a number of articles 12, 23, 24, 4 and 5, they have never been brought under our national legislation and they have never been considered. So not all the domestic remedies have been exhausted. And I think it's not only breach of procedures, but it's an infringement on our sovereignty because I think the sole purpose of the committee and convention is to develop national protection systems. And I think our state is trying very hard to establish such national protection systems. And I think no one prevented the applicant to question the law on legal support, which overall I think meets all the required standards. However, if there are questions in terms of this law, I think nothing prevents the applicant to go to the court or to apply it to the Constitutional Court of Narnia. Furthermore, you should note that our National Human Rights Institution established under the Convention is A+ institutions under the Paris Principle, and we invite the National Human Rights Institution to represent the interests of Ali in the courts in our domestic system.
Let me start with one question. Which is you raised the issue of reasonable accommodations and the role of Mark in making sure that John has sufficient information to provide informed consent. Can you please give us some idea of what accessibility measures the state has taken to make information around the consequences of marriage available to people with intellectual disabilities like John? And once the concerns were raised by Mark, what measures were taken by the state to ensure John's access to information and any necessary accommodations to ensure that he could make an informed decision? And sorry, a follow-up to that is there a legislative basis for these accessibility measures or accommodation measures in the national legal system?
I think Ali had basically by appointing a support person to Ali, state is taking care of that person by allowing and putting into place different safeguards to protect his interests. And in that sense, the role of the support person is not only to inform him about all the consequences of decisions of choosing the alternatives, but also being able to implement the decision that he takes. In that case, we must say that the safeguards were fully exercised in the sense that the decision was considered in two instances, at the level of the registrar, and the decision was then further reconsidered in the court. So, and as we said earlier, nothing prevents Ali to also apply to national courts to protect his rights in terms of if he has any issues in terms of the law on legal capacity and its exercise. Did I answer the question?
I think perhaps the issue of what the state has provided for could better be answered by the advocates representing the government. Our organization is really mainly concerned with the safeguarding of family values and traditional values, which we believe in this case are at risk.
In your opening comments, you mentioned specifically this, that you're a faith-based organization and you're very concerned with the family values. But being in front of the Committee on the Rights of Persons with Disabilities, I would like to understand also what legal arguments are you making in terms of what's the notion of marriage that is embedded on Article 23 of the Convention on the Rights of Persons with Disabilities and how it's protected?
Okay. Yeah, being a faith-based organization, of course we have a family value. And then talking about the Article 23 of the UNCRPD, also it talk about the family rights of the person with disability. And then John is also Ali is the family member. And then being a family member, they need to respect the value of the family as well as, because that is also the family rights, because without respecting the value, he cannot have a better family life, or he cannot have a better life in his family. Because taking that in mind, also because if he got married with Ali, and then maybe he will not able to live in the permanent family. Just he will live for 1 and 2 years, or maybe just for the 6 months in the temporary family. So it will violate the rights of the family. So it is related to Article 23.
I mean, our deeply held belief is a family is a union of men and women. But we're very strictly law-abiding citizens, so we don't agree with this law, and altogether we will be starting a campaign to repeal the law on same-sex marriage. But however, we use all the possible legal remedies to protect our family values.
In addition, on a purely legal basis, you will find that one of the purposes of the objections procedure is to prevent marriages of convenience. And as far as we are concerned, marriages of convenience obviously breach traditional family values, because once the parties are married for the minimum possible time, they will divorce. And so it's important that marriage be seriously scrutinized before it's allowed to go ahead, so that it's very clear that it's an actual real marriage and not really just only for the purposes of getting a visa. You will find there's been an argument that there's discrimination. There's no discrimination, because the provisions here apply to all marriages. The fact of there being a foreign national is a very relevant consideration, because there are serious statistics in the Kingdom of Narnia of marriages of convenience between foreign nationals and citizens of Narnia, simply for the purposes of getting visas. And this has nothing really to do with John's disability. It's a general issue. You find there is nothing really that specifies. The only issue that's in the law is where it says there could be an objection based on a non-sound mind. But we feel that it's really more general than specific to John.
Because if Ali will divorce John after some time, after getting married, maybe he will go in the anxiety, and then family does not want their member to live in the anxiety. So it is also we ensure the rights of family, or ensure the family rights of John, because nobody wants to have their family living in the anxiety and depression.
objection?
The government of Narnia would just like to make a quick comment that we do not agree with the repeal of of same-sex marriage, as Respect for Our Families is saying. We do, however, agree that there needs to be further investigation in this particular case for the purposes of preventing John from exploitation or possible abuse.
So thank you to both of our amicus representatives. Let's go to the government for rebuttal for 10 minutes, I think. Oh, John for rebuttal first. Sorry. Thank you.
So we want to point out that, first of all, that the state arguments reflect a wrong and discriminatory comprehension of the notion of safeguards that is definitely not admissible under the CRPD. Safeguards must be put in place to prevent abuse from the person exercising the role of support and not to go against Sean's will. On the contrary, safeguards must ensure that Sean's will is respected. We want to say that persons with disabilities do not need protection. Actually, what they need is rights. They don't need anyone to speak for them. In this case, safeguards were not put in place, and this is evidenced by the fact that Mark assumed on the basis of John's disability that he was not ready, and he notified directly to the marriage register that he opposed the marriage. And so this is a case of substitute decision making that is not allowed under CRPD. And we will also like to mention that no person is tested before getting married. And that is not to prove that this is a case of discrimination on the grounds of disability.
We also would like to mention that John didn't get appropriate support because the support person Mark didn't give John any explanations or recommendations, suggestions, or tips or regarding his financial consequences of his marriage. But the support person's role is to give John's pros and cons and other explanations so that John can make a right decision by himself. It's not the support person's role to make a decision by himself and then write a objection letter to registrar. It's not the support person's role. So the government, in this case, because the government appointed Mark as John's support person, the support person did not do his role very well. So it's not kind of state responsibility to to do some training to Mark to give right support. And then we also would like to mention that the government argued that the government job is to make sure John and Ali are in the same understanding, but every person for the marriage, every couple, I don't think they were in the same understanding. We cannot measure that. So the government just appointed Mark, the support person for John, and then the government wanted to get some evidence, receive some evidence for proving John is in the same understanding as Ali or same understanding as others. It's hard to prove. It's really hard to prove. It's almost impossible. And The government also argued that the process of making a decision of the government was appropriate, but in our case, the decision-making process was not appropriate because John himself did not write an objection letter. Mark, the support person, by himself wrote a letter, and then the government just took that objection letter and made a decision based only on that objection letter and John's argument, on the Mark's, the support person's argument. They didn't do any further investigation regarding this matter, and they didn't ask for help from any family member of John who knows John very well. So I think the process of making a decision by the government in this case was not appropriate.
Thank you very much. Now we go to the government.
So I feel like in order to answer this question fully, we need to start in the beginning of the process. When Mark and Allie first went to the registrar let the marriage go through. And doing so, he let these signs that we all are speaking of just go, and he let the marriage proceed. It was only until Mark wrote the objection letter that the registrar just then took into consideration these different circumstances under this marriage. I think saying this, the objection made by Mark was then approved by the chief registrar. So John's objection letter upheld and was considered valid. I think these steps, I think the government of Narnia and all of us, we can't know for sure what Mark's intentions were by writing this letter, but what we do know is that the government of Narnia, it is our responsibility to ensure that our citizens are being prevented from any signs of exploitation and abuse. And the system we have in place, we believe, provides the safety and the safeguards necessary in order for all of our citizens, and specifically in this case John, from being exploited in any way.
To add, Mark is not making the decision of marriage for John. He simply wrote the objection letter because he wanted further investigation, again, for protection. And because he has legal standing, he does have a right to put forth this objection letter. Also, we would like to state that if you take this situation and put it onto a different couple, it could still go through the same processes. So this isn't because John has an intellectual disability. Or even, and this is also not a case of sexual orientation discrimination because, again, every couple, if they are intending on getting married, they need to put forth their intention 2 months prior.
And the chief register and the state need to be conscious and need to do all the procedures accordingly, because getting married and a civil marriage is a solemn procedure. So you need to be very aware, and if you need to take all the steps, the only thing the state is doing is like looking for more information, looking for more investigation in order to be fully sure that all the parties involved understand what marriage is and what are the financial consequences of marriage.
And back to the support, we are providing as much support as we can, and we are trying
to make John to feel as independent as possible. So that's why he has only a supporter, only for financial reasons. And this is respect for difference and acceptance of person with disabilities as part of human diversity and humanity, and a general principle of convention. And it also, the support varies from person to person. In John's case, he has this kind of support. So it's not one size all fit.
A question, because you just mentioned that that Mark didn't make the decision on behalf, it's just the procedure. But then what he said is that he's unsure whether John fully understands the implications of the decision to marry, and then what you're saying is that you need actually to more investigation and more evidence, because this is a very solemn act, to see if actually John's understand the decision that she's making. So what I would like to understand is how you're planning to determine that. Is through a functional assessment, through a mental capacity test? So what's the standard that you're looking for in terms of proving that John has the capacity or not to understand the act of marriage?
In that case, we can interview John with another family member that is agree with his decision, and he can be interviewed at the court or the chief register. Okay, sorry, I was like, what? To make sure that he can understand what is the Marriage Act referring to, and we can also interview Ali in that process to make sure what are his intentions related to the marriage. If he is aware that if they if they gave false information, they can be, I don't know, it can be, the marriage can be annulled, or I don't know if I'm using the correct words in English. So, because if it's a solemn act and they have to give current information related to it, so we can interview both of them and the process, and we can be interviewing other familiars that are agree with their decision.
Yes, and in addition to that, we will be interviewing people from the club where they met for the first time, because it's very important. They can see, they can say something more. In addition to that, also John might have all standard assessment test based on our Mental Health Act.
And again, we would be doing this with anyone, not just in John's case.
I just wanted to clarify one point. Maybe I missed it before in your first intervention about the Marriage Equality Act. That couples must formally notify the state of their intention to marry. So what does formal notification consist of? Does it mean that they have to present themselves in person solely?
Both parties need to show up in front of the chief registrar and physically put in their intention. And there's put their intent to marriage.
Okay, thank you.
So thank you very much. I think we have 1 minute per team to sum up your arguments. So let's go to the applicants first.
Okay, we believe the decision of the committee is a really good opportunity to, it's a fundamental case to ensure the rights of persons with disability, since legal capacity is the condition to exercise all human rights. We believe that public authorities must understand once and for all that persons with disabilities are equal before the law, and leave behind arbitrary standards of normality, rationality, and understand that if we tested every person in their ability to get married, and if we started evaluating if they fully understand what getting married implies, maybe nobody would pass that test, supposing that is actually testable, let's say.
Thank you. Let's go to the Rainbow Coalition.
Dear committee, in the terms of the decision of the Registrar of Marriages, we must reiterate that it was made on the basis of stereotypes and discrimination based on disability, sexual orientation, age, and citizenship. We would like to summarize that this decision and the Narnia Marriage Act contravene significantly Narnia's obligation in accordance with the CRPD, namely Article 4, 5, 12, and 23. All these violations, as a whole, have one goal: impede Mr. John and Mr. Ali to enjoy their human right to marry. Therefore, we are asking the Narnian government to change the Narnia's Act of Marriage to reach compliance with the CRPD and allow John and Ali to get married.
The objections of Mark are irrelevant, are against the law, and the government's action of complying with Mark's demands is also a mistake by the government, and they should change. Thank you.
Thank you very much. Let's go to Respect Our Families.
We would say that the objections were correct because it's important to protect family values, and the government has been doing that to uphold the sanctity of marriage and prevent marriages of convenience, leading to fraud and exploitation of our people. The objections procedures in terms of the law, there is no discrimination whatsoever, and the support person was not informed before the notification in order to give appropriate information.
Yeah, we also want to stress on the fact that we're really not questioning John's ability here. It is Ali's intention, background that we need to research on, and we also believe that Mark did not go and make a decision himself. He's actually representing the entire land of Narnia because we really believe in solidarity and safeguard for our citizens, so he's actually protecting the entire community. And yeah, we're asking the government to uphold our values, and it's a land of non-violence and peace and love.
On behalf of the government of Narnia, we would just like to say that in no circumstance would we ever want to prevent the solemnization of marriage. We believe in the values and the morals behind marriage and how much value that can bring to our citizens and society as a whole. Our responsibility, though, in this case, is to ensure that John can fully and safely exercise his rights. We believe that we have taken in the necessary safeguards and precautions in order to prevent the exploitation of any of our citizens. The human right to marriage is for all citizens, and we will ensure that we put in more services and more procedures in order for every citizen to exercise this right. Thank you.
Thank you very much. The committee would like to thank each of the representatives for their thorough and articulate interventions today. We will withdraw, adjourn, and we will reconvene in approximately 30 minutes? About 30 minutes.